All right, I'm headed back down.
Okay.
Sucks. Okay. Okay. All right, I'm ready on Giles. All right. Okay, this is case number 234436201, the people versus Joseph Dwayne Giles. Defendant is charged with one count of operating while intoxicated second offense notice, and today is the date set for an arraignment on a bench warrant. Appearances, please.
Good morning, Your Honor. Christina Ritter on behalf of the people, P number 83505.
For the record, Your Honor, Janice Stevenson appearing on behalf of Mr. Joseph Dials. Good morning again, Mr. Dials. Sir, please tell the judge your full name.
Joseph Dwayne Dials.
Today is the date set for an arraignment on a bench warrant. Ms. Stevenson.
Mr. Dials will stand mute, waives the reading of the information, asks that a plea of not guilty be entered on his behalf, and that the matter be rescheduled for final pretrial conference. Your Honor, we do have discovery in this matter. Mr. Dials missed court last time because he had a bad Zoom connection. He lost his connection when he went to Zoom back and the meeting had been locked, and he came in person today.
The court will enter a not guilty plea on behalf of Mr. Dials and set the matter for a final pretrial conference. February 23rd, how many do I have?
Five.
Okay. February 23rd. At 9:00 a.m. Bond will continue. Anything further?
Nothing from the people, Judge. Thank you.
Nothing on behalf of Mr. Dials. Thank you, Your Honor.
Did he post a bond to get this date?
I can't pull up my JIS, Judge. Mr. Dials, did you pay a bond to get today's court date?
Yes,
Ms. Flanagan?
Your Honor, for the coming person.
That's fine, sir. Ms. Flanagan?
Yes, $10.
All right, then bond will continue. Actually, I'm gonna set that at 9:04. All right, anything further?
No, thank you, Judge.
No, thank you, Your Honor.
All right, Mr. Dowd, you're all set. Have a great day. Stay safe. Happy New Year.
All right, thank you for your time.
You're welcome. All right, are we ready on? Southern, are we ready on Southern?
Ready on Southern, Your Honor?
Did you all speak to Mr. Curitan?
Not this morning yet, Your Honor.
Okay. All right, I'm ready on Southern. These are case numbers 224497101. People versus Eugene Lewis Southern. Defendant is charged with retail fraud. That case is scheduled for a review. And then we have case number 2344826. 01 2344828 23451 234512101 and 234512301. And in each one of those cases, the defendant is charged with retail fraud, and today is the date set for final pretrial conferences. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Mr. Eugene Southern. Mr. Southern, sir, when you're able to do so, please tell the judge your full name.
State your name, sir.
Eugene Lewis Southern.
Thank you. Today is the day set for review and final pretrial conferences. Ms. Stevenson, how are you proceeding?
Your Honor, with regard to the final pretrial conferences, actually, with regard to all cases, Your Honor, I believe that these cases are part of a global resolution stemming from a felony, Your Honor, whereas the unadjudicated cases are to be dismissed per plea agreement. And I need to check something on the adjudicated matter.
Ms. Ritter?
That is correct, Judge. So with respect to the cases set for a final pretrial today, there was a global resolution made in Third Circuit Court regarding Mr. Southern's felony cases. From my understanding, Your Honor, my colleague wrote me an email yesterday saying that there was a final pretrial conference scheduled for those felony matters on January 17th. And I guess that's when they'll decide if that global resolution will be accepted on that day.
Did not adjourn Mr. Southern's cases because he already had a court date and he said it was gonna be a global resolution.
That may be
I believe so, Your Honor.
Okay, well, let me just say this about the global resolution. I'll adjourn one final time in an attempt at a global resolution. But I'm not going to manage my docket based on a certain court schedule or scheduling. So,
Judge, we have a jury trial set for January 23rd. If it pleases the court, Mr. Southern will waive his right since the jury trial asked the matter to be scheduled for bench trial on January 23rd.
well, that won't be possible because if it's a jury trial and Mr. Southern is not going to go to trial, then that means I'm going to have another jury trial.
We have 3 in there, I think.
What day did you say?
January 23rd, Your Honor.
And his isn't even the one that's going. What happened with Young and Edwards? Did we just
That may be resolved as well.
Well, yours may be resolved.
Correct. Thank you, Judge, for that clarification.
I mean, okay, we can do a waiver, but it's the rubber meets the road. I'm not gonna be adjourning my things based on circuit court. So if there's no global resolution, then we're gonna resolve these or they're gonna go to trial. Or we'll continue a not guilty plea. On behalf of Mr. Southern, asked for final pretrial matters, I will continue the matters on the trial track, and then Mr. Southern, with respect to the trial, your lawyer has indicated that you will waive your rights to a jury trial and have the matter heard by the court should they proceed to trial. Is that what you want to do, sir?
Yes, ma'am.
I'm sorry, did you say yes, ma'am?
Yes, ma'am.
Okay, and sir, do you understand that if I accept the waiver from you today, that should the matters proceed to trial, I will be the only decision maker? Do you understand that?
Yes, ma'am.
Has anyone threatened you in any way or promised you anything that was not placed on the record to get you to enter into this waiver or to waive your right to a trial? Jury trial, jury trial. Ms. Ritter, any objection from the people?
no objections, Your Honor.
Having no objection from the people, finding that the waiver has been made freely, knowingly, and voluntarily, the court accepts the waiver. And then with respect to the waiver trial, I'm gonna move the date from January 23rd to January 25th. At 12 noon. With respect to his review case, the last note that I have in my book for Mr. Southern is that he's on remand.
Right.
So if he's on remand, you don't have that?
That's the one. It's over in that cabinet under names.
Oh,
You have
under
to-
May?
You have to review on May 10th.
Oh, it's on for review today though. It should be on for the earliest day.
Discharge on.
Oh, no, okay, go. Go read that. I mean, with respect to that one, I'm probably gonna just, send him probation and, sentence him to 93 days in Wayne County Jail, credit for 93 days served, close the case out. Cause the last note I have is that he's on remand.
That is our absolute request, Your Honor.
All right. Then, that's what I'm gonna do with respect to the case, number 224497101. The court is going to, rescind the probation. Oh, this already happened. So I'm looking at his order. And I already gave him 60 days in the Wayne County Jail, credit for 60 days served. And then it was a non-reporting probation. He can't have any new violations, but he's on remand. So I'm just gonna let the 60 days stand and I'm gonna close the case out. I
Okay,
think that
thank you.
I did it the way I did it because maybe at the time we didn't know if he was gonna get out of jail, be in jail. Maybe something like that happened. And I was
Yes,
just,
yes.
all right, so we're gonna just give him credit for 60 days served, which I already did, and then we're gonna close this with improvement.
Thank you, Your Honor.
Welcome. All right. So, with respect to the bench trial, do we want, well, since it's a bench trial now, I don't need to do another final pre-trial for the global resolution. We could just show up on the bench trial day and we know it's a global resolution.
I mean, that's,
I
That's
think
not-
so, and I don't,
Well, here's the problem with that. If it's on the docket for bench trial, the jail is gonna bring them in person. So maybe we should do a final pre-trial conference Friday, January the 19th.
whatever pleases the
oh.
court is fine with me, Judge.
Ms. Ritter, did you say it was the 17th that they were waiting?
Yes.
Okay, that sounds fine.
Well, or we can do a final pre-trial the same day of his previous jury trial, and then if there's a global resolution, but if it's on for bench trial, they're gonna bring them in person. So let's do a final pre-trial conference January 23rd.
Okay.
Okay,
And then that way, we'll know if they need to bring them in person on the 25th. All right. Oh, I went up there and see if we bring that paper down. January 25th. Okay. That's what it- All right, anything further with respect to Mr. Southern?
No, thank you, Your Honor. The people thank the court for their consideration in this matter.
nothing on behalf of Mr. Southern. Mr. Southern, do you get it, or you want to talk to me some more?
No, I get it.
Okay, all right, nothing on behalf of Mr. Southern, Your Honor.
All right, then, Mr. Southern, you're all set, sir, and Stay safe. Have a great day despite where you are. Stay safe, okay?
Thank you.
You're welcome.
His pretrial.
Everyone, I'm gonna send you to a breakout room. Please accept to join the breakout room and the lawyers will begin to speak with you. Do not leave the breakout room until you have spoken with a lawyer. Oh, never mind, Mr. Mateo must be. Mateo is ready. What happened? Mr. Puritan, Vice left it. Oh, no, he's in breakout room. Oh, no, I don't need that yet. I was just saying.
Okay.
Okay, these devices I'm gonna remove. They'll come back when they're ready to go. All right, we're ready on Allen. This is like old times.
Yeah.
Reaching for God. Now, how is it that Mr. Allen isn't ready now? All right. This is case number 2.
Hello?
Stop. We got to know better than that. It's 2024. We're in court. It's been going on too long for us not to know that we don't just say hello on this. All right, I'm ready on Allen. This is case number, hold on a second. Like somebody's playing with my mics. All right, this is case number 204523101, the people of the state of Michigan versus Omar Craig Allen. The defendant is charged with 1 count of retail fraud. Today is the date set for a pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people and Representative on behalf of the complainant, witness Meyer, did appear this morning, Judge.
And for the record, Your Honor, Janice Stevenson appearing on behalf of Mr. Omar Allen. Mr. Allen, please just say your full name.
Omar Craig Allen.
Sir, a couple of things. We can hear very well, so you don't have to project loudly into your device. And then you probably can stay back from it a little bit.
Something wrong, sir.
All right, today is the date set for pre-conference. How are we proceeding?
On behalf of Mr. Allen, Your Honor, we will continue the plea of not guilty. We would ask that this matter be set for final pretrial conference, and we would request discovery.
The court is going to continue a not guilty plea on behalf of Mr. Allen. Set the matter for a final pretrial conference. March the March 6th at 9:00 a.m. Discovery should be submitted to the defense by February the 6th. Bond will continue with absolutely no contact with any Meyer. I did notice on some, looking at that the bond condition set by the magistrate, on November the 9th said no contact with the Meyer on 8 Mile, on West 8 Mile. Let me be clear, bond condition is no contact with any Meyer store. The complaining witness is Meyer Corporation. The complaining witness is Meyer Corporation. So the bond is changed to no contact with any Meyer store. Anything further?
No, thank you, Judge.
I think half of Mr. Allen. Thank you, Your Honor.
All right, then we're all set until, March 6th at 9 o'clock. Have a great day, stay safe, happy new year.
All right.
Ready on Brooks?
Ready on Brooks.
These are case numbers 234501301 and 234501501. People of the state of Michigan versus Sharon Janine Brooks. Defendant is charged in each case with 1 count of gambling, disassociated person. Today is the date set for an arraignment. Appearances, please. Mr. Moody.
May it please the court, Abdullah Mugni here on behalf of Sharon Brooks, who appears today via Zoom. Ms. Brooks, could you please unmute your mic and say your name for the record?
Sharon Brooks.
Today is the day set for an arraignment, Mr. Moody.
Your Honor, today my client is going to stand mute today my client is going to stand mute and waive the reading of information.
The court enters a not guilty plea on behalf of Ms. Brooks, set the matter for a pretrial conference. February the. How many do I have on February the 13th? About February 14th. I just wasn't gonna say 2. I already wrote 5 strikes, waiting on you to.
Oh.
Look, I'm talking about just now.
Oh.
I was thinking you were gonna say ready now. All right, I feel like I put more on February 14th.
That's so far.
Only had 2?
Yep.
And are they both set by me?
Yeah.
Okay. All right, February 14th. At 8:25. Mrs. Ruby asked to bond. Ms. Brooks, can you remove your hand from your face, for?
I'm sorry.
And Mrs.
Yes.
Ruby asked.
Yes, Your Honor. So Ms. Brooks is a nonviolent offender. She has no violent criminal history to my knowledge. She's absolutely not a flight risk, as right now she is at work and has ties to the community. She has nowhere else to go. She lives in Oak Park, which is not too far from Detroit. She plans on showing up to all their court dates just as she showed up to this one. So there is no worry that she won't show. Your Honor, we ask for a personal bond as she does not have the money to pay for anything more, and she's going to do everything right going forward.
Court will set bond in the amount of $500 personal bond, no contact with any casino. No contact with any casino. Anything further?
No, thank you, Your Honor.
All right, then we're all set. Have a great day. Stay safe. Happy New Year.
You're good to go, Ms. Brooks.
Okay, thank you.
You're welcome.
I was gonna say something. I said, have a great day, stay safe. Then Mr. Mookie said, we need to go. And she said, okay, thank you. Y'all don't be, I think I be speaking French sometimes.
Sorry about that, Judge. I hope you had a good New Year, by the way. I haven't seen you since.
I did,
Yeah.
Mr. Mookie, but it's not just you. Sometimes it's the same thing, Ms. Dixon. I'll say something and then Ms. Dixon say the same thing I said, then they understand it, so I'm gonna have to try a little bit more English for lawyers.
Sorry about that, Judge. I thought you were being nice to your client. Not used to you being nice to me.
What day did I say?
Um,
See, it's too much, it's more work for me having to write it.
February 14th.
Oh, I should have known that. All right. All right, I'm ready on Burton. I don't see Burton. Okay, I'm ready on, we did nine. I'm ready on Gardner. Did Ms. Harris ever come back?
No.
Can you call down to Judge Holmes' courtroom and see if she's scheduled?
Okay.
Ms. Gardner, I need you to be stationary in an upright position and ready to attend court. Turn on your camera, please. We've had this conversation all morning. This is case number 224552201, the people of the state of Michigan versus Kia Marshella Gardner. The defendant is charged with 1 count of assault aggravated, and today is the date set for a pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
May it please the court, Abdullah Mugni here on behalf of Kia Gardner, who appears today via Zoom. Ms. Gardner, could you please unmute your microphone and say your name for the record? Your full name.
Kia Gardner.
Your full name.
Kia Marshella Cassandra Gardner.
Thank you. Today is the day set for pretrial conference. How are we proceeding?
Your Honor, today we'd like to move for a dismissal based on the complaining witness's failure to appear. Does not appear that they are here today.
Ms. Ritter.
Judge, I don't see the complainant witness, Ms. Tamia Gardner, in the waiting room. However, it is scheduled as a first-time pretrial conference. Respectfully asking the court to adjourn the pretrial conference to give the complainant witness one more opportunity to appear before the court.
There is one unidentified device that I just brought in. However, they have the same last name. Is this my case?
Judge, so according to the investigator's report, it looks like the complainant witness.
Stop shaking your head. How do you know? You couldn't possibly know. You couldn't possibly know. So I'm talking to the prosecutor in this particular moment. All right, Ms. Ritter, is this my case?
Thank you, Judge. So looking at the investigator's report, it looks like the complainant witness is the daughter of the defendant. So this will be an appropriate matter for courtroom 338.
Thank you. Mr. Flanagan, can you call courtroom 338 and see if they want me to send Ms. Gardner now, or should I give her another date? And the witness is, well, I don't know if the witness is here.
Yeah.
I'm gonna find out.
All right, thank you.
Can the Motorola that I just let into the courtroom, can you unmute and state your name for the court? The Motorola, unmute and state your name for the court.
My name is DeMario McDay.
Thank you, that's it, that's all. State your name for the court.
Thank you.
Thank you. All right, with respect to Ms. Gardner, how did you log into my courtroom this morning? Did you type in the Zoom ID number, or did you go to the court's website and click on my name?
I'm logging in with the Zoom number.
All right, do you have that Zoom number right in front of you?
Yes.
Zoom number for me, and where you see a 9, you see there's a 9 in that Zoom ID number?
Yeah, 339.
Change that to 338. So put an 8 where you see the 9, and then you're gonna
Yeah.
log off. You're gonna log off of my Zoom and log in to courtroom 338. That's Judge Austin Garrett. And this case should be in his courtroom.
Okay.
They're expecting you.
Okay.
All right, have a great day, stay safe, happy holidays.
Same to you.
Eric Burton is in the audience. And, Ms. Brooks is still,
You said, who was it on?
Burton, Eric Burton. What's on, so, it's out of issue, so.
Okay, Ms. Stevenson, did you all talk to Mr. Burton?
Mr. Burton is ready, Judge.
All right. Counsel. Like you set up for a trial.
I know, yeah.
Oh, okay, I was thinking that it might have been something else. All right, I'm ready on Burton. Come on up, Mr. Burton. This
Good
is
on that,
case
Mr. Mobley.
You want to take this, Janice? I didn't get a chance to speak with him. Actually, I could do it, actually.
Okay.
I'll do it.
Yeah.
Sorry, Judge. Sorry,
Yeah.
Judge. Sorry.
Yeah.
Leaving.
I wish y'all could see my face. See, y'all can't see my facial expressions when I'm this far.
I hear it. I'm picking it up and I'm
Okay, you hear?
leaving. And I'm leaving.
Okay, this is case number 2045046001. The people of the state of Michigan versus Eric Darnell Burton. The defendant is charged with 1 count of assault aggravated. Today is the date set for pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
May it please the court, Abdullah Mugni here on behalf of Eric Burton. Mr. Burton, could you please say your full name for the record?
Eric Darnell Burton.
Today is the date set for pretrial conference. How are we proceeding?
So it does not appear that the complaining witness is here today, so we are going to move for a dismissal based on the complaining witness's failure to appear.
Ms. Ritter.
So, Your Honor, according to the people's notes, it looks like June 9th of 2023, the complaining witness appeared, the defendant did not appear, and at that time, the court issued a KPS. So I'm going to ask the court to deny defense counsel's motion and move to a final pretrial in this matter.
Tell me that date again.
June 9th, 2023, Your Honor.
The court is going to deny defense counsel's motion. Mr. Mooney, how do you want to proceed?
Then we'd ask that you set this for a final pretrial and we request discovery on the matter.
All right, the court will continue a not guilty plea on behalf of Mr. Burton. Set the matter for a final pretrial conference, April the 3rd, 2024 at 9:00 a.m. Discovery should be submitted to defense by March the 4th. Bond will continue with no contact with the complaining witness. Anything further?
No, thank you, Judge.
No, thanks, Your Honor.
All right, Ms. Ritter, notwithstanding the Complaining witness's appearance on June the 9th. At the very least, it's been almost a year, so if you could please, the people could contact that witness and make sure they know that Mr. Burton has appeared and that if he doesn't accept a plea, if the matter isn't resolved at final pretrial conference, that a trial is going to be set, okay?
Understood, Judge. Thank you.
All right, Mr. Mooney, your client had his hand up. I'm gonna have Officer Krabs go get Ms. Stevenson.
Okay,
See if
perfect,
there's some record.
perfect. Thank you,
Alright.
Judge.
You're welcome, sir. Have a seat and the lawyer will come talk to you about the reason you had your hand up. All right, I'm ready on. I'm ready on Johnson. Okay. Counsel. The matter proceeds. Why not set aside 3 days? For the- I mean, I had this on for today, tomorrow, and Friday.
I didn't think not have that.
You think so?
Oh.
Maybe Mr. Pierce said he had a slew of witnesses. Did he have a slew of witnesses?
His witness looks like the same people as mine, so.
He came in yesterday.
Oh, okay, yeah, we just don't get it.
Okay.
Ms. Eason,
Yes, Judge.
you gonna talk, you at the podium, but I need you to talk to, you already did?
Yeah.
Oh, it's nothing for the record?
Yes, there is something.
So then is he gonna come back? Oh, Mr. McDay, I'm gonna send you to a breakout room, sir, I'm sorry. Accept to join the breakout room, Mr. McDay, and wait for the lawyers to come into that breakout room to speak with you. All right, Ms. Stevenson, place your appearance on the record.
For the record, Your Honor, Janice Stevenson appearing on behalf of Mr. Eric Burke.
All right, Mr. Burton had raised his hand and I didn't allow him to speak, Ms. Stevenson.
Your Honor, Mr. Burton is requesting removal of a GPS tether previously ordered by the magistrate. We believe Mr. Burton presents absolutely no risk of flight in that he did attempt to zoom in, was unable to do so, was directed to come to court, which he did immediately.
Any response from the people?
Judge, so I don't see any notes that there has been contact between the complainant witness and the defendant. However, due to the capious history, like the people stated previously, there was a pre-trial conference back in June where Mr. Burton did not appear. I'm going to ask the court to deny defense counsel's motion and keep the GPS tether, Judge. This case is from 2020. The people do want this case to come to its lawful conclusion, and we just want this case to move forward.
It's something about being in person. You know, I rejected a lot of it. I rejected a lot of it because I like not having to come, you know, use my gas every day. But one thing about being in person is you can sure see people's body language and facial expressions and how they move, how they talk. And I was just wondering why, when the prosecutor said that Mr. Burton failed to appear the last time that he rolled his eyes, acting like he didn't fail to appear. And acting like that failing to appear is not an important thing. And that's why he on lock with that tether, because he failed to appear. And then if I had on a tether and I couldn't zoom in, I would have came down to court too. Because I would have been like, you know, they got this tether on me and I want to get it off so I can not appear the next time. So let's not take lightly that you failed to appear on an aggravated assault, which I believe is a 1-year misdemeanor. So let's not take that lightly. And then it causes me not to want to remove the tether. You see, I don't understand why people do things and they standing right in front of the judge who's trying to make a decision. So it seems to me that he doesn't take it seriously that he failed to appear. Ms. Stevenson?
Your Honor, I'm searching for information right in front of me. I don't have it as to when the tether would have been placed on. But I do believe it's been on for several weeks at this time. And yeah, as much as I would like to say that my client should respond the way Mr. Burton responded by coming to court when he couldn't get on Zoom, unfortunately, I just can't really say that. So it does speak volumes to me about Mr. Burton's desire to behave responsibly with regard to this court date, with regard to this entire case, and be here when he's supposed to be here and refrain from having any contact with the complaining witness. I don't believe we've had any type tether violations since this tether was placed on. And I think that Mr. Burton understands the gravity of this situation. He understands the serious nature of these proceedings, understands that he's to follow court orders, and despite his failure to do so in the past, he's making amends and being here when he's supposed to be here and staying away from the complaining witness. I renew my motion for removal of the tether.
Court is going to grant defense counsel's motion to remove the tether. There's no contact whatsoever with the complaining witness, and the court is going to set the April 3rd court time for 9:04. Should Mr. Burton fail to appear, his bond is going to be $5,000 cash surety plus the GPS tether. Anything further?
No, thank you, Your Honor.
I have nothing for the record. Mr. Clerk, indulge me, tell me the complainant's name. Ran in here on the stuff.
I have it right here,
Oh, thank you, Judge.
but I will tell you. Here, Mr. Clerk. I'll tell you. I don't think I wrote it here.
Tomorrow, January.
Tomorrow, January. Okay.
All right, sir, have a seat and wait for a copy of the court's order. I sent Mr. Johnson a request to start his camera 5 times, and he didn't. So I'm gonna put him back in the waiting room, and then we'll see, what happens. Okay. I'm ready on. Oh, I don't have everybody highlighted. Let me highlight some other people.
I can go back to my office, Judge?
Yes.
Okay, thank you.
All right, I'm ready on long. Because the, so. Quicker when I see it right here. Oh, well. It's not. Oh, wait. Oh, okay. Yes. All right, this is case number 234529701, the people versus Bradley Carl Long. The defendant is charged with 1 count of gambling, disassociated person. Today is the date set for an arraignment. Mr. Mooney, your appearance, please.
May it please the court, Abdullah Mugni here on behalf of Bradley Long, who appears today via Zoom. Mr. Long, could you please unmute your microphone and say your full name for the record?
Mooney, I just know why you start calling the people by their last name.
I got yelled at last time I said the first name.
You didn't. I said I liked it.
Okay, I'll go back. I'll fix that.
Because that's what I was going to start doing in January. You thought I was fussing at you, Mr. Mooney.
I'll go back to my old ways.
All right, go ahead, Mr. Mooney.
All right, Brad, could you please say your name for the record?
Yes, sir. My name is Bradley Carl Long.
Thank you. Mr. Long, please excuse our levity right there. All right, today is the date set for an arraignment, Mr. Mooney.
Your Honor, today, we are going, or my client is going to stand mute and waive the formal reading on information of his charges.
Court enters a not guilty plea on behalf of Mr. Long, set the matter for a pretrial conference, February the 14th at 8:25 as to bond.
So, Your Honor, Mr. Long is not a violent criminal. He has no track record that he is a danger to the community. He is not a flight risk. He lives in Royal Oak, and he's shown up to his court date as you see today. He plans on showing up and cooperating fully with everything that happens in this case. He has no intention of ever going back to any casino, and he made one mistake in a moment of weakness. He doesn't want to break the law. He hasn't broken the law. And in 15 years, he's had a clean streak, and he's going to continue down this path of good doing. So, Your Honor, we ask that because he is currently searching for employment, that he get a personal bond and he, have a chance to right any of his wrongs that he may have done.
Court is gonna set bond in the amount of $500 personal bond, no contact with any casino. Anything further?
No, thanks, Your Honor.
All right, then we're all set until February 14th. Mr. Long, have a great day. Stay safe. Happy New Year to you. All right, I'm ready on. Let's see. I'm ready on. Can you call Ms. Bumpus on Payne? See if she can, maybe she can come to the courtroom right here.
Wellington.
Yeah, I don't see, let me check my. She did say. Yeah, can you, see if she can come to the courtroom? All right, so then that leaves, Mateo, are you ready on? Are you ready on Mateo, Mr. Movement?
I'm ready. I'm Mateo, Your Honor.
All right, and then, all right. This is case number 224442701, the people of the state of Michigan versus Ileana Mateo. Ileana Maria Mateo. The defendant is charged with 1 count of operating while intoxicated, 1 count of security fail, and 1 count of license plate illegal use. Today is the date set for a final pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Ileana Mateo. Ileana, please say your unmute and say your full name for the record.
Ileana Maria Mateo.
All right. See, I can't remember right in this file. And in my book.
Okay, you got it.
Today is the day set for final pretrial conference. How are we proceeding?
Your Honor, my client and I have had the opportunity to discuss this matter. We've had the opportunity to review together in advice of rights form. And at this time, it is my understanding that my client wishes to offer the court a plea of guilty, waiving those rights incident to trial. Excuse me, Your Honor, the plea would be no contest, based upon the potential exposure to civil liability stemming from any statements that might be made in court today. The plea of no contest would be to counts 1 and 3, with a dismissal of count 2 per plea agreement with the people.
Ms. Ritter, is that the people talking?
That's correct, Judge. That is the people's offer at this time, and we have no objection to a no contest plea.
Okay, all right, thank you.
Okay, there you go. All right. Okay, unmute yourself, for me. Whoops, I think we did it at the same time. All right. Okay, and, Ms. Stevenson, before I take the plea, can we go and break up?
Yes, Your Honor. Okay.
Ritter.
Okay.
Ms. Ritter, you wanted to break now?
The go-to for restaurant.
All right, there it is. Okay. Okay. All right, so by her words, your lawyer has indicated that you want to give up your right to a trial and enter into a plea today. Is that what you want to do?
Yes, that's correct.
All right, I'm gonna share my screen. And on my screen, will be an advice of rights form. My question to you is, have you had an opportunity to review for yourself or to go over with your lawyer your constitutional rights?
Yes.
And when you did that, did you understand your constitutional rights?
Yes.
Do you understand that this is a misdemeanor and therefore you have a right to a trial? However, if I accept a plea from you today, you are going to be giving up your right to a trial. Do you understand that?
Yes.
Has anyone threatened you in any way or promised you anything that was not placed on the record to get you to enter into this plea?
No.
Drawing your attention to number 8 on the advice of rights form, are you currently on probation or parole?
No.
All right, and then finally drawing your attention to number 11 on the advice of rights form. Do you understand that by entering into this voluntary plea, you may be giving up your right to an automatic appeal, and if you were to change your mind about the plea, you would either have to request permission of this court to set aside your plea or request permission of the circuit court to appeal?
Yes.
With that understanding, do you still want to give up your right to a trial and enter into this plea today?
Yes, I understand.
All right. Who's going to place the factual basis on the record? Ms. Ritter?
I can, Judge. I just need one moment to pull up the investigator's report, Your Honor.
Okay.
I'm ready, Judge.
All right.
Ms. Mateo, on October 31st, 2021, were you operating a motor vehicle on southbound I-75 freeway at or near Hubbard Avenue?
If
Yes.
I might object, I think that
It's
her
a,
plea would be no contest.
I'm sorry.
Thank you.
That's right. I'm sorry, Judge. On October 31st, 2021, near southbound I-75 freeway at or near Hubbard Avenue in the city of Detroit, the complaining witness, Trooper Mandy Coy, has filed a sworn complaint in this court stating that on the date and location stated above, the defendant, Ileana Maria Mateo, contrary to law, did operate a vehicle upon a highway I-75 freeway while having an alcohol content of 0.08 grams or more per 210 liters of breath and or under the influence of alcoholic liquor, contrary to MCL 257.625 subsection 1, and did carry or display upon a 1999 Ford Ranger a vehicle, a registration plate not issued for that vehicle, contrary to MCL 257.256.
Ms. Stevenson, is there a stipulation as to that factual basis for the purposes of the plea?
And yes, and for the purposes of plea, we stipulate the blood alcohol content was 0.14 for purposes of the plea.
All right. Court receives a stipulation, and with that stipulation, the court receives a no contest plea.
Happy New Year, everybody.
To counts 1 and 3 and a dismissal of count 2. The court sets the matter for sentencing February the 14th at 9:00 a.m. With respect to the sentencing, you have a right to be sentenced in person, or you may consent to being sentenced on Zoom. Which do you prefer?
Please.
All right, then the court will set the matter for Zoom. And also, you must submit to a pre-sentence investigation and substance abuse evaluation. Probation is going to contact you. If they cannot reach you by phone, they're gonna leave you a message and mail you a letter directing you to contact them. Make sure you respond to their letter or their phone call so that I can have the proper required pre-sentence investigation on the date of your sentencing, okay?
Okay, thank you.
You're welcome. Have a great day. Stay safe. Happy New Year to you.
Thank you,
You too.
Your Honor.
All right. Okay, I'm ready on Cloyd. Hey, Ms. Deason, I'm not gonna keep asking your clients to turn on their cameras 5 and 6 times.
Okay.
I'm ready. Wait. This is case number 204544001, the people of the state of Michigan versus Leroy Jonathan Cloyd. Defendant is charged with 1 count of assault or assault and battery. Today is the date set for a pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Leroy Cloyd. Mr. Cloyd, sir, please unmute and say your full name.
Leroy Jonathan Cloyd.
Today is the day set for pretrial conference. Ms. Stevenson, how are we proceeding?
Your Honor, on behalf of Mr. Cloyd, I'm going to move for dismissal for the complainant's failure to appear at either today or what I believe to have been the first pretrial conference, despite its appearance on the docket, scheduled for November 22nd.
Ms. Ritter.
So in my system, Judge, it looks like the pretrial that was scheduled on November 22nd was canceled. I don't know for what reasons, but I'm going to ask the court to deny defense counsel's motion and give the complainant witness, Mr. Donald Moon, one more opportunity to appear before the court.
Oh, yes. Yes, okay. The court is going to deny defense counsel's motion and grant the people's request. The case on November the 22nd, it was canceled. It wasn't held. And that was
understood. Okay.
I'm waiting on your client to stop his indignation at my statements. That's what I'm waiting for.
Oh, thank you,
Sorry
Your
about
Honor.
that,
Mr.
Jude.
Cloyd, and you just want to face the camera, please, Mr. Cloyd, and be attentive and face the camera. Thank you, sir.
But I know, one thing I know for sure is that if Mr. Cloyd didn't show up, he would be so ever grateful for the court's policy of allowing an individual a second chance to show up. So we're gonna be so ever grateful that grace and mercy works in both directions. That's what we're gonna do. In this new year, we're gonna be grateful that grace and mercy works in both directions, because certainly if there's no grace for one side, there's no grace for the other side. All right, so as I indicated, the November date was canceled. It was not held because that was the day that the court's docket had been overloaded by the magistrates. I want to say in error, but I don't know if it was error or not. And then docket management simply removed those dates and adjourned them to a future date. So that being the case, the court is going to deny defense counsel's motion, grant the people's request for a one-time adjournment, giving them an opportunity to notify and locate the complaining witness and notify them of their obligation to appear before this court. I am going to set that pretrial conference for February the 14th at 8:36. The complaining witness is required to appear. Failure of the complaining witness to appear will most likely result in the matter being dismissed unless the people have a valid explanation as to why the complaining witness could not appear or should not be required to appear. Bond will continue with no contact with the complaining witness. Anything further?
No, thank you, Your Honor.
Yes, Your Honor, on behalf of Mr. Cloyd. Mr. Cloyd, I believe is on personal bond, Your Honor, but he has been residing. He continues to have no contact with the complaining witness, Your Honor, and abide by other court orders. He has been residing at the Christian Guidance Center, Your Honor, in that the matter will continue, and so that Mr. Cloyd can avoid homelessness, we would ask that he be ordered by the court to remain housed at Christian Guidance Center during the pendency of these proceedings.
Well, Ms. Eason, what if I had dismissed it today? Then you just gonna be homeless? I mean, what do you mean? What does that have to do with me?
Mr. Cloyd, let me do that. Okay, so Mr. Cloyd does have some prospects for employment outside of the state of Michigan. Were had the case been dismissed today, he would have left the state of Michigan. Now that he will not have permission to do that, he'll have to stay in Michigan. He doesn't have anywhere else to live in Michigan. He could stay at CGC if it's ordered by the court, Your Honor.
But you didn't ask me for him to leave the state of Michigan.
No, we're not requesting permission to leave the state of Michigan at this time.
All right, the court will, Ms. Dixon, let's go on a break, all right?
Okay.
Ms. Ritter.
2-1, Judge?
Well, no, it looks like I'm gonna have to move the courtroom to another one, so let's go to 2.
Okay.
Okay, I think we're in now. Okay, yes. Okay, all right, so we've had an opportunity to speak in a breakout room and the court will continue the bond condition of well, continue or institute, because I don't know if they already had it on there. But the bond condition, he will remain at the Christian Guidance Center as condition of his bond, and he will have no contact with the plaintiff witness or the Russell Street address. Anything further?
No, thank you, Your Honor.
No, thank you, Your Honor.
All right, then we're all set. Have a great day, sir. Stay safe, and we'll see you, February 14th.
Thank you.
You're welcome. All right. All right, I'm ready on that day. This is case number, oh, you said that other one's supposed to be non-public? Okay, this is case number 214436901, the people versus Demario McDay, defendant is charged with retail fraud. Today is the day set for pretrial conference appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people and a representative on behalf of the corporate complainant witness Meyer has appeared this morning.
Janice Stevenson appearing on behalf of Mr. Demario McDay. Mr. McDay, sir, please unmute and say your full name.
Demario McDay.
Today is the day set for pretrial, Ms. Stevenson, how we proceed?
Thank you, Your Honor. Mr. McDay will continue his plea of not guilty. We would ask that this matter be set for final pretrial conference, and we would request discovery, Your Honor.
The court will continue a not guilty plea on behalf of Mr. McDay, set the matter for a final pretrial conference, March the 6th at 9:00 a.m. Discovery should be submitted to defense by February the 6th. Bond will continue with no contact with any Meyer store. No contact with any Meyer store. Anything further?
No, thank you, Judge.
No, thank you, Your Honor.
I'm going to remove Mr. Johnson. This is my last attempt to get Mr. Johnson to turn on his video. I'm going to remove him, and I'm not going to hear his case before my trial. So somebody better call him, because I've sent him a request 10 times to turn on his camera. I'm ready on Curitin. Mr. McDay, you're all set, sir. Have a great day. Stay safe.
Thank you. God bless you. Have a good day. Happy New Year's.
Thank you. Same to you.
All right. Janice, I can
I'm
tell
ready
you.
on Curitin. This is case number 205930501, people versus William Curitin. Defendant is charged with license plate illegal use. Today is the adjourned date set for review, Ms. Stevenson.
Janice Stevenson appearing on behalf of William Curitin. Mr. Curitin, sir, please unmute and just say your full name.
William Curitin.
All right, Mr. Curitin was here yesterday, and I was gonna check my notes and see if I told Mr. Curitin what he said. I told him, and Mr. Curitin has been absent. Ms. Curitin has been absent from the court since 2022. I don't even have those notes anymore. They're like in archive. So I don't think I told him that. And if I did, that was like applicable if he was gonna come right back. Not if he was gonna go on year and some hiatus. So, the report from yesterday from the probation officer, it stands. He has to clear up the warrant, and I don't remember the other things that were on there. And we're gonna give them, yes.
Okay. We want the court to know that the warrants have been cleared up at this point. That other cases is actually showing now closed, that he's complied with
So
the
then
probation.
it has to pay some money, I think, then.
There's no money left owing on this case unless Mr.
That's-
Flanagan can correct me.
No, on another case, hold on, I'm gonna pull it up.
Okay.
I don't remember who the probation officer was. Ms. Bumpus, I'm gonna do something a little different, because that case is supposed to be Haida. So you can go in the hall, I'm gonna actually go, we're gonna go in Ms. Stevenson's little office and do the case.
Okay,
Okay,
thank you.
well, right outside her office, we're gonna go right out there and do the case, because I can't put the courtroom back in there. Okay. Where you go? Okay, so Ms. Stevenson, I'm looking at the report from yesterday, and it said, he owes, this is Curitan, okay, so he owed $654 in fines and costs. Mr. Flanagan, has zero balance?
Zero balance.
Okay, so now he has zero balance. He owes $540 in outstanding tickets. And it said he failed to do the driver's improvement class. And he received that new weapons charge.
Okay, so I would ask the court to, I'm not sure about the tickets yet, but I would ask the court to give Mr. Curitan an opportunity to complete the driver's improvement class, Your Honor. Well, I would ask the court on behalf of Mr. Curitan to waive that final condition of compliance, Your Honor. If the court is not inclined to do that, I would ask the court to give Mr. Curitan an opportunity to complete the driver improvement program. I have given him a referral to eBay, Your Honor, so he can contact that agency to get that class scheduled.
I feel like I shouldn't even do Mr. Johnson's case. That was so utterly ridiculous. You can squint your eyes and do whatever you want. I sent you 10 requests to start your video camera. We've called your case 3 times. Now you're gonna look like we inconveniencing you. You inconvenienced us, sir. You inconvenienced us and the people who are waiting for their trial to start. You inconvenienced us. Mr. Flanagan, pull up case number 22-056-21501. Tell me what's the next court date on that?
It's closed.
Okay, thank you. All right, so his weapons case is closed. He, can you see that, would you be able to know if he owes $540 in tickets? He didn't say he had any, the warrants, so they might be civil infraction.
Excuse me, can I talk or?
No, sir, I see your hand, I see your hand to hand. No, sir. Those are civil infractions. Okay, Ms. Stevenson, I'm gonna grant your request. Case is closed without improvement. Anything further?
Nothing on behalf except of Mr. Curitan, except thank you very, very, very much, which I think is what Mr. Curitan wants to say. Right.
All right, then we're all set. Ms. Curitan, have a great day and stay safe.
What, I just want to be 100% sure.
So we're
I'm
gonna
okay.
and you can ask whatever million questions you want to ask to Ms. Stevenson and Mr. Mooney, because the court has ruled. All right, except to join breakout room number 4. I'm ready on Johnson. This is case number 194636401. The people versus David Johnson. Defendant is charged with assault or assault and battery. Today is the date set for pretrial conference appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
May it please the court, Abdullah Mugni here on behalf of David Johnson, who appears today via Zoom. David, could you please unmute your microphone and say your full name for the record?
David Johnson.
Today's day set for pretrial, Mr. Mookie.
Your Honor, it does not appear that the complaining witness is here today, so based on that, we're going to move for a dismissal based on that complaining witness's failure to appear.
Ms. Ritter.
Your Honor, I don't see the complainant witness, Ms. Lashery Williams, in the waiting room. However, Your Honor, this case is from 2019 and is scheduled as the first time pretrial conference. I respectfully ask the court to adjourn the pretrial conference and give the complainant witness one more opportunity to appear.
Court is going to deny defense counsel's motion for dismissal, grant the people's request for an adjournment, giving them an opportunity to locate and notify the complaining witness of the obligation that they appear before the court. I am adjourning the case to February 14th at 8:36. The complaining witness is required to appear. Failure of the complaining witness to appear will most likely result in the matter being dismissed unless the people have a valid explanation as to why the complaining witness could not appear or should not be required to appear. Bond will continue with no contact with the complaining witness. Anything further for the record?
No, thank you, Your Honor.
No, thanks, Your Honor.
All right. Okay, Ms. Stevenson, I'm gonna put you and this Hyder case in a breakout room. We're gonna come out to your outer office.
Okay.
So Hyder in a breakout. And that's gonna be breakout room number 4. So Ms. Stevenson, you can send your device to breakout room number 4.
Okay.
All right.
You can leave, David. You're all set.
Okay. So, you'll get back in touch with me on the next one?
Yeah, either me or anybody.
No, we live on YouTube. Don't have conversations on my Zoom. Court, the case is over. If you need to speak with the defendant, he can go to a breakout room.
Here, I'll just call you. All right, David?
Okay.
All right. Talk to you soon.
All right.
Just step to the resolution.
Okay. Good, because you can hear me calling him the defendant. I'm sorry. April 2nd, converting the 10 days of workforce to 10 days of community service to be reduced to 5 days of community service if he completes it within the 90 days. And he'll get to keep the HIDA. Ms. Ritter, there's something Ms. Stevenson is trying to work out with that last case, but I'm getting ready to start my trial. So if you agree to change the bond condition, you all can let me know. But otherwise, I'm not gonna make a decision on the bond condition. So whatever information she's trying to gather, if you agree to it, that's fine. If not, she'll have to do a bond, hearing, okay?
Okay, Judge, and that's for the HIDA case?
No, that's for this Mincy case, who they left in the breakout room so long, he left and came back. He's now in the waiting room.
Okay, got it, Judge. All right.
Okay, all right.
Thank you.
Thank you for your patience.
New Year, Your Honor.
Happy New Year. Happy New Year. All right, Mr. Pilgrim, come on up. Ms. Stevenson, I told Ms. Ritter, if you all agree on that bond condition, fine. If not, though, I'm not gonna make a decision. Like, it's gonna stay.
It's not ready yet. I have to do some more work on it.
Right, so, but he came back and he's in the waiting room.
Okay, I'll go and find out.
So you, Ms. Ritter, you can log off, I guess, and then if Ms. Stevenson gets the information, she can call you, but I'm gonna start my trial and I'm not gonna go back on the record with NC.
Okay.
Okay,
Okay.
so if Ms. Ritter agrees, I can sign an order.
Okay, could Mr. Payne pay instead of doing
No,
community
no,
service?
he don't.
Okay, okay.
Tell him to do some community service. Tell him I said services to bring me paper, space be occupied, and to keep the height.
Okay, okay.
All right, I'm ready on Pilgrim. This is case number 2344667. 01, the people of the state of Michigan versus Raymond Pilgrim. The defendant is charged with child abuse 4th degree and 1 count of assault or assault and battery. Today is the date set for trial. Appearance, please.
Good morning, Your Honor. Tina Ripley on behalf of the people, P83688.
And may it please this honorable court, good morning. Attorney Byron Pitcher on behalf of Dr. Raymond Pilgrim stands at the defense table to my left. We're ready to proceed.
All right, your name, sir?
My name is Raymond Pilgrim.
And is your middle name Vincent?
Vincenti.
Vincenti, thank you. All right, then, are there any preliminary matters before we begin? I do see some individuals in the courtroom.
Should I just make a motion to sequester any witnesses accepted for my officer of charge?
And can your officer in charge put his appearance on the record for him?
You know, pick it up.
All right, thank you.
I joined in that motion for sequestration. There's one point that's come to my attention this morning I'd like to bring to the court's attention, if I may.
Okay, go ahead.
Your Honor, it's my understanding they don't have their complaining witness. I'm not sure how they're gonna go forward with these allegations about the complaint.
I don't know either, but it's child abuse, and depending on the age of the child, they might not need to complain. At least that's asked to one of the counts. Yes.
Judge, the people are able to proceed based on other evidence, like a video of incident happening. So we have witnesses who can identify the people in the video, one being the child. So we don't believe that we need the child to testify.
But to
That
show,
was the case.
And this is my position. This is my position. So today is the day set of trial. If people believe they can proceed, we are going to proceed. On a child abuse case, a complaining witness is, I don't believe is necessary. Now, I don't know how that'll play out as a charge of assault or assault and battery, but at the conclusion of the people's case, if you believe that they have not met that burden, then of course the court will entertain your motion.
fair enough, Your Honor.
All right, so the motion for sequestration is granted. It is mutual. If there's anyone currently in this courtroom that will testify today or in the future on behalf of the people or on behalf of the defense, you must leave the courtroom. Remaining in the courtroom will disqualify you from testifying on behalf of the defense or on behalf of the people. All right, nobody moved, and there are 4 people in the courtroom and the officer in charge. Okay, any other preliminary matters?
Judge, you've made your ruling. I just want to make sure the record is clear. Because their complaining witness is not here, I'm going to move that the charges be dismissed. I think you ruled, I just want the record to be clear as to my request.
And that motion is denied at this particular juncture. Okay,
Thank you.
all right. We want to change this. All right. Will there be any opening statement on behalf of the people?
The people would, waive their opening statement if there's no objection.
Any objection to the people waiving?
None, Your Honor.
And will there be an opening on behalf of the defense at this time?
There will not.
Okay, then the people may call their first witness.
Thank you, but I would just, for the record, I am in your waiting room.
Oh.
There will be others.
And so, Mr. Pitts, also, if you're going to show a video, well, I don't see a computer.
I actually do have a computer.
Oh, okay. So if you're gonna show a video, all you need to do is log into the Zoom, and then I'll give you sharing privileges. We'll look at it up there.
I'll just sort of play it by ear as to what they, Judge, you have a cup for water?
Yes. Officer Crafts and you too.
Okay.
Thank you. All right.
I remember at this time, you would call Gino Grisham.
1 second, Your Honor.
Okay.
Oh. Okay.
I think the OIC went to get them. Yes, okay. Give your name to the court reporter. And then step towards me, sir. And before taking a seat, raise your right hand for me. Sir, do you swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
You may be seated in the witness box. Sir, there's a mic. There's a mic, in front of you. It moves just like this mic. The arm of it moves just like this. Adjust that mic so that it can, we can make sure that it projects your voice. And then counsel, you may proceed.
Thank you, Judge. Good morning. Can you please state your name for the record?
Yes, my name is Gino Grisham.
And where are you employed?
I'm employed at Pasture Elementary School.
What elementary school?
Pasture Elementary School.
Okay, thank you.
And were you employed at such elementary school on or about September 22nd of 2022?
Yes, I was.
And where's that elementary school located?
19811 Stouffville, west side of Detroit.
City of Detroit?
Yes, ma'am.
County of Wayne?
Yes.
And what was your role at Pasture Elementary back in September of 2022?
At that time, my role was the attendance agent.
And what do you do in that capacity?
In that capacity, monitor and maintain attendance, particularly focusing on chronic absenteeism, part of the culture and climate team where we deal with behavior, attendance, and just overall functionality of the school.
And who was your immediate boss?
Principal Hall and Dr. Gilbert.
And do you see Dr. Pilgrim in the courtroom today?
Yes.
And would you be,
We'll stipulate to his presence.
All right,
thank you, would the record reflect the witness, the
Yes.
defendant is Mr. Ramon Pilgrim?
the record was so reflect.
Thank you, Judge. And are you aware of a student named Isaiah Ashford?
Yes.
And how long had you known Mr. Ashford, at that time?
At that time, I've known Isaiah for about 2.5 years.
And were you, aware of an incident that happened with Mr. Ashford on or about September 22nd, 2022?
Yes.
And what happened on that day?
On that day, Isaiah, during lunch duty, Isaiah was in a fight. He punched a kid. So at that time, the kid that he punched ran over to me. Isaiah still was trying to go after the kid, so I restrained Isaiah, took him in through the side playground door. At that time, I did release Isaiah. Isaiah then attempted to run back outside again. At that time, I restrained Isaiah a second time, and we were walking through. Dr. Pilgrim saw that I was struggling with Isaiah. So Dr. Pilgrim started to follow us. We went over to the auditorium where I bring Isaiah in, sit Isaiah down. Dr. Pilgrim's talking to him.
This is a long narrative.
So,
I'm sorry.
so you're in the auditorium.
Yes.
All right. Are you aware of surveillance video cameras within the school?
Yes.
And are you aware of one in the auditorium?
Yes.
So you'd be aware that whatever happened,
Objection leading.
so it's kind of foundational.
Well, she's telling him what he'd be aware of. It's leading.
Would you know if there's video cameras in the auditorium?
Yes.
So if something in the auditorium, if something happened in the auditorium, would you expect it to be captured on video?
Yes.
And did you in fact see a video that I showed you of what happened in the auditorium?
Yes.
If I can direct your attention to the screen, can you tell me what it is we're looking at here?
Yeah, you have to stand up.
Yeah, that is the auditorium.
Okay, and is that the auditorium at Ashford Elementary School?
Yes.
All right. And is this a fair and accurate representation of the video that you had seen the incident occur on?
Objection leading.
Oh,
Just tell him the question.
No, she said, is
I'm
this,
asking
she
the
said, is this?
Yeah,
Yes.
is this a fair and accurate representation?
Yes.
And Your Honor, I would put the information on people's proposed exhibit 1.
Objections.
All right, then People's Proposed Exhibit 1 is admitted as People's Exhibit 1, and this is a video of the auditorium.
Correct, Your Honor. And it's 48 seconds long, and may I publish?
You may.
Thank you.
Yeah, with the court's permission, I'd like to stand,
Yes,
sitting down the light.
You may, yeah.
Yeah.
Once, eventually the plexiglass is gonna go away. They said once it break down and fall apart. Okay. All right.
I'm going to pause at 13 seconds. Do you see the 3 individuals within the auditorium?
Yes.
And who are they?
Isaiah, Dr. Pilgrim, and myself.
And which one are you?
From my direction, I'm off to the left, closest to the door.
And are you standing up?
Yes.
And who is in the seat?
That's Isaiah.
And who is in front of Isaiah?
That's Dr. Pilgrim.
Going back to 6-second mark. You just saw, you remember the incidents that happened that were relayed on that video?
Yes.
How old was Isaiah at that time?
Isaiah had to be 10 years old,
And what grade was he in?
5th grader.
What happens when you enter the auditorium with Isaiah?
At that time, Isaiah's still kind of fighting a little bit. Dr. Pilgrim's in on it as well. He's coming, he's telling Isaiah to stop. Isaiah's making threats to Dr. Pilgrim. Dr. Pilgrim's arguing back with Isaiah. I sit Isaiah down. Isaiah then, he doesn't want to hear what I'm saying. He doesn't want to hear what Dr. Pilgrim's saying, so he gets up to walk away. At that point, Dr. Pilgrim grabs him by the neck, sits him back down in the chair. And then Isaiah, after Dr. Pilgrim let him go, Isaiah's kind of like, oh, I can't breathe. You choked me. Gets back up in the chair.
I'm objecting to what Isaiah said is hearsay and asked that it be stricken.
And Judge, I would have respectfully, it's not hearsay, it's actually an exception to hearsay of 803.3, that existing mental, emotional, physical condition. He's responding as to what it's a physical condition of him. I can't breathe.
This is overruled.
Thank you, Judge. So let's backtrack a little bit. See in the video, Isaiah begins to stand. Is that yes?
Yes, I'm sorry, yes.
And where does he go when he stands?
He's headed towards, so you see the one door we came in, he's headed towards it's a door on the opposite side. He wants to leave. He doesn't want to hear what we have to say.
So it'd be fair to say he stands up and he turns to the right.
Yes.
Okay. He didn't go forward.
No, he did not lunge at Dr. Pilgrim.
He did not what?
He did not lunge at Dr. Pilgrim. He
He
walked towards the door. He didn't lunge at Dr. Pilgrim, he walked towards the door.
Okay. So he didn't rush Dr. Pilgrim?
No, he just stood up and walked towards the door, turned to walk towards the door.
Was Isaiah moving in a threatening manner?
No, Isaiah was not moving in a threatening manner.
Tell me about what you see when Isaiah stands up and turns to his right.
Like I said, Dr. Pilgrim grabs him by the neck, he sits him down. Then after he lets him go, Isaiah saying, I can't breathe, choke me. And then he kind of, after about 25, 30 seconds or so, he sits back up, and then he's having a conversation with Dr. Pilgrim. They're going back and forth. Isaiah was threatening Dr. Pilgrim. He said he would kill Dr. Pilgrim. He knew his family.
Objection to the hearsay.
Yes.
Sustained.
So there's only certain circumstances which you can say what someone says.
Oh, okay.
When you say that Mr. Pilgrim grabbed Isaiah by the neck, what did he use to grab him by his neck?
He used his hand.
Okay. And where did he, I guess, push him down to?
To the chair.
Okay. Did you recall seeing the state that the chair was in after this happened?
Yeah, at the end when Isaiah was calm and able to go back to class, when he got up, I did notice that the chair, the back of the chair was leaning in the row behind it.
And that was reflected on the video also?
Yes.
How were you feeling when you saw this happen?
Relevant.
I think it goes to the actual incident happening, like the fear that it could have instilled.
Sustained.
So about how long did Mr. Pilgrim have Isaiah by the neck?
Anywhere between 3 to 4 seconds.
And after he lets go, Isaiah says, how long does Isaiah say that he can't breathe for?
that went on for a second. You can see him he's on the floor in the video, probably, like I said, 20 or 25 seconds or so. And then he's sitting back up and he's still angry, crying. But as far as like saying, I can't breathe, he choked me for about 20 to 25 seconds.
So there was crying?
Yes,
Was he crying before you guys went into the auditorium?
yes,
Okay. Was he emotional?
yes.
What is Mr. Pilgrim's role at the school?
It's actually not, Judge. I'm gonna ask that you refer him, he's actually earned the title of Dr. Pilgrim, and ask if he can address this, so.
I'm not sure what doctor, I don't know, is it PhD or?
PhD.
I agree for PhD.
I mean, can I just refer to him as the defendant?
No, that I hate worse. Although it's a new court rule, I guess I'm gonna have to try to change that way I feel about that. I agree. I mean, I guess I agree. But it's not required though. I mean,
Judge, respect, I mean, I understand, I'm not trying to be, like, I'm not trying to.
no,
when I
I'm
do it, I'm not trying to be disrespectful, but
I agree. So, I suppose when Mr. Pitts made the objection, I've not ever thought of it.
I guess I don't know what the legal objection is.
Right, that's, so, I know, but, let's just proceed. I'm not gonna require it. It might be, I guess, considered respectful, but I'm not gonna require it. With this court, everybody's equal, I guess.
I will do my best.
Okay.
So what is Dr. Pilgrim's, or what was Dr. Pilgrim's role at the school?
He was the assistant principal.
And being the assistant principal, what was his job? What was his duties?
If he knows, Your Honor.
If you're aware.
She needs to be laid.
With your understanding to you, what were his roles?
Yeah, my direct correspondence as far as Dr. Pilgrim was to assist in overseeing the attendance efforts and the behavior efforts. And I only had other, these were directly correlated to me dealing with.
I'm gonna object to this, Your Honor, unless he knows what Dr. Pilgrim's role is within the school, has firsthand knowledge, was told or something. I asked him to,
well, I was.
Hold on, no, sir.
I think it calls for speculation without a foundation that he knows this man's job title, job description, job role.
Or just ask specifically as it relates to him,
Well, that's part of his job description, what his role is as it relates to other faculty members.
No, so the objection is overruled at this point. And because I believe the witness, notwithstanding the question, so I'm not sure how you worded your question, but notwithstanding the question, the witness was responding only as it related to him. He said, as it relates to me,
okay,
this was his role. So I'll allow the answer.
so as it relates to you, what was Mr. or Dr. Pilgrim's role?
Like I said, overseeing and helping myself, the attendance section with the attendance efforts, and then on our culture and climate team, which I'm a part of as well, and Dr. Pilgrim is as well, and our leadership team, I know Dr. Pilgrim dealt with the behavior as well.
Would it be fair to say that when Isaiah is at school, that the school faculty members, yourself included, have care, custody, or authority over Isaiah?
Yes.
And at that time, about how tall was Isaiah?
5'9", 5'10".
And about how much did he weigh, roughly?
Probably 135, 140 pounds, somewhere there.
With the objection, unless he knows, Your Honor, I actually do not guess.
Just like estimate size with him?
Well, that's called a guess, Your Honor.
Sustained.
Yeah, I don't know his actual size or weight.
Was, how about in comparison to Dr. Pilgrim?
He's much smaller.
You were involved in, when you witnessed this incident happen, what did you have to do in response to it?
you know, when it happened, it all happened so fast. Initially, not much, but then like the next day, Dr. Pearl said that I needed to write a statement, that the statement was to be given to him.
So, did you write a statement?
Yes, I did. At that time, I did write a statement, and I gave it to Dr. Pearl.
And Dr. Pilgrim, the one who's involved with the incident,
Correct,
and you had to give your statement directly to him?
correct,
Okay. And you actually wrote two statements, correct?
correct.
And that first one that you had to give directly to Mr. Pilgrim, that was closer in time to the incident happening?
Yes, yes,
Okay. And your second statement, would be fair to say that was a little further away from the incident?
yes.
Tell me why you had to write a second statement.
There's objection leading, there's no testimony that he had to write anything.
Tell me
As
why
the
you
leader said.
wrote a second statement. Tell me why you wrote a second statement.
Another investigation by the district was being done, and the person handling the case said that I needed to write another statement and tell it honestly, because I disclosed to her that the original statement that I wrote was not as honest, as I had given directly to Dr. Gilbert. I didn't state that he grabbed him by the neck in the first statement. I said he pushed him down to the chair.
So was your second statement more truthful?
Yes.
And what's the reason why your second statement was more truthful than your first?
You know, I've asked myself over and over. I mean, I'm in no way Dr. Kruger put fear in my heart or anything. But at that time, I felt for some reason the need to make it seem less than it was, because I was given a statement. Dr. Kruger doesn't make it right or wrong. He didn't coerce me or anything. I did not give it honestly, because I'm giving it to Dr. Kruger, and we had a relationship, and thinking about that, you know, it was wrong. But then when the second investigation came around from the district, and just understanding what happened to Isaiah and the state that it all happened, I told my truth in that, and I was given the opportunity to write a fully truthful statement, and that's where we get the second statement.
Nothing further at this time, Judge.
All right, 1 second. Thanks. Okay, so it's not in the end.
Right, yeah.
Okay. All right, you may proceed.
May it please the court, good morning, Mr. Grisham.
Yes, good morning.
Good morning. Listen, I want to direct your attention back to September 22nd, 2022. You testified today that you were working at Pasteur School?
Yes.
Okay. And on on September 22nd, 2022, you observed two students fighting, correct?
Yes.
Okay, one of those students was named Isaiah Ashford, correct?
Correct.
And the student, and he was sort of getting the best of the other kid, correct?
Sorry.
I'll withdraw that question. You saw Isaiah hit the other young man very hard, did you not?
Yes.
And you wanted to remove Isaiah from the area in which the fight occurred, fair statement?
Correct.
And Isaiah didn't want to willingly leave, did he?
No, he was not, like I said.
Right, he wanted to continue the fight from what you observed, correct? Yes
Right.
or no? Yes or no?
Yes.
Okay,
Just give him a chance to answer.
I answered mine.
It's cross-examination.
And actually, you had to tussle to remove Isaiah from the playground, correct?
Yes.
Okay, and it's because Isaiah was attempting to go back outside and fight the other student, correct?
Yes.
In fact, you had to tussle, you had to physically put your arms around Isaiah to get him into the building, correct?
Correct.
You had to physically put your arms around Isaiah to drag him in the auditorium, correct?
Well, by that point, he was walking. I wasn't dragging him.
Okay, fair enough. Can you play the video, please? Let's just go to when the individuals walk in.
Well, then that would be interfered.
Yeah. Okay. Stop. Thank you. Okay, thank you. We're doing the best. I got it. Okay. If I may, of course, permission. Oh, thank you. Is there a way we can back it up just a touch? Let's just go. That's fine. That's fine. That's fine. Mr. Grisham, you see the video, correct?
Yes.
There's a young man in a blue shirt, correct?
Yes.
Okay, and you said that's Isaiah Ashford, correct?
Yeah.
Now, why you didn't know was weight. You estimated his height to be around 5'9", 5'10".
Yes.
Okay, and that's you with your arms wrapped around him, correct?
No, well, I'm holding one arm, the other arm, we're going down the steps, so it's awkward.
Fair enough. Your arms are, those are your,
arms
answer my
crossed.
question, please, sir. You're in the white shirt, correct?
Yes.
You see what I'm pointing to right here? That's your arm, correct?
Yes.
Your arm is around Isaiah, correct? Yes or no?
I have both of his arms.
Right. You've got your arm, in fact, you had your arms around him since the moment you walked into the auditorium, correct?
Yeah.
You're pulling him into the auditorium, correct? Yes or no?
No.
But you have your arms around.
Yeah.
Okay.
Just keeping him from breaking away.
Right, keeping him from breaking away because you know that he wants to go back out and fight this other young man. Isn't that correct?
Yeah.
Dr. Pilgrim is back here. He's not even in the auditorium. Fair statement to me.
Yeah, Dr. Pilgrim, when I was bringing him to the auditorium.
That's an objection, non-responsive. My question to you is, that's Dr. Pilgrim, yes or no?
I believe so. It was Dr. Pilgrim and LV. He was directly behind us.
Fair enough. Either way, at the time you and Isaiah Ashford enter the auditorium, it's just the two of you initially.
Yeah.
Okay. And then shortly thereafter, another individual walks in, correct?
Yeah.
Okay. So you are physically trying to prevent Isaiah from getting away to protect the safety of other students, correct?
Yes.
And you wouldn't put your arms around somebody if it wasn't necessary, correct?
Correct.
You did it because you felt it was necessary to protect the safety of other students, correct?
Yeah.
From Isaiah Ashford, correct?
Yes.
Okay, because Isaiah Ashford was angry at that moment, correct?
Mm-hmm.
Upset?
Is that a yes or no?
Yeah, I'm sorry, yes.
Angry, correct?
Yeah.
He was, from what you observed, he appeared to be volatile, correct?
Yes.
And he appeared to be, from what you observed, willing to go back out and continue the fight. Yes or no?
Yes.
And you didn't want that to happen, did you?
No.
No? And as a person employed by the school district, you did what you felt was necessary to isolate Isaiah from the rest of the student body, correct?
Yep.
And that's why you had your arms around him and brought him into the auditorium. Fair statement?
Yes.
And this occurred, once again, September 22nd, 2022, right?
You know, yeah, if that's what the video, so I can't remember the exact date, but the video says that, yes.
We'll stick to it. It happened September 22nd,
Yes.
2022. Okay. And you indicated that you gave more than one statement regarding what occurred within that auditorium, correct?
From the playground to the auditorium, yes.
Okay. And you've indicated that the day after the incident, Dr. Grisham asked you to give him a statement. Fair statement?
Dr. Gresham is not anybody at the school.
Oh, I'm sorry. You're right. Dr. Pilgrim. Dr. Pilgrim instructed you to give him a statement, correct?
Yes.
And you were intimidated. Strike that. You gave the statement to Dr. Pilgrim the day after the incident, correct?
Yes, I believe so.
Okay. Sir, isn't your witness statement, didn't you give a statement November 18th? If you don't remember, you don't remember giving a statement November 18th?
No, I probably did. It was a few different.
My question is, do you remember giving a statement November 18th?
I don't.
Okay, if I showed you your witness statement, might that refresh your memory?
Yes.
Your Honor, I'm gonna ask permission to approach you, man.
I'm sorry, counsel, did you show, Madam Prosecutor, what
I
you're
did.
voting?
So we have the same.
Yeah, I just hear that up there. You want my?
No, I'm back. This is fine. Okay. Satisfied, sister counsel?
Yeah, I just don't want to, or I don't want to have your vote product back on.
Sir, I'm giving you a report. Do you recognize that document?
Yes.
Okay. That's your witness statement, is it not?
Yes.
Read whatever you want, but I want to draw particular attention to the date on it. You see that date?
Yeah, 11/18/2022.
Just let me ask you, now that you've reviewed, have you reviewed that document?
Yes.
Okay. Does your memory refresh as to when you gave the report? Is your memory refreshed as to when you gave the report? Sorry, that wrote the statement. Is your memory refreshed?
I'm not clear on what you mean.
You said.
I know I had to write a statement.
Do you now remember that you wrote the statement November 18th?
Well, yeah, now that I see that, yes.
Okay, you didn't write it the next day, did you?
I feel like I wrote something the next day as well.
Okay. Is there another statement, September 23rd? Okay, fair statement. The statement I just showed you, you wrote that in your own handwriting, correct?
Correct.
And you're an honest person, fair statement?
Yes.
Truthful?
Yes.
Dr. Pilgrim never threatened you?
No.
Okay, he's always been professional with you,
Yes.
correct? And there's nothing in and you made, this was the statement I just showed you was the first statement you ever wrote as it relates to the events of September 22nd, correct?
Yes.
Okay, there's nothing in this statement about, and choking a student is pretty serious, grabbing him by the neck, that's serious, correct?
It is. Yes.
Okay, nothing in your statement about your, Dr. Pilgrim having his hands around Isaiah's neck. There's nothing in the statement about Dr. Pilgrim having.
Right, in the original statement, I did not state that because I knew I was giving it to Dr. Pilgrim.
Okay, there's nothing in your statement about Isaiah saying he can't breathe, correct?
Not in the initial statement, no.
Okay. There's nothing in your statement about Isaiah crying, is there, in the original statement?
No.
Okay, those are all very important factors, correct?
Yes.
And you left all of those out, correct?
Yes.
And you wrote this statement when it was fresh in your mind, fair statement?
I was a little ways away.
Well,
but either way, yeah, I still knew the situation.
Knew the situation,
yes,
right?
I knew the situation.
And you wrote a second statement almost 7 months later, correct? You gave a second statement, fair statement?
Yes, 7 months.
Well, on or about April 10th, 2023.
Yes.
Okay. And that statement's typed, correct?
Yes.
Did you type it?
Yes.
You typed it yourself?
Yes.
Okay. And you changed your story in the second statement?
Yes, I gave the actual.
You changed your story, yes or no?
Yes.
When you were in the auditorium, you observed Isaiah get angry when Dr. Pilgrim told him to settle down, correct?
Correct.
And you observed Isaiah Ashford continue to escalate the situation, correct?
Correct.
And certainly that kind of student escalation gives you pause as to the safety of other students, fair statement?
Correct.
So that at that time, you personally were concerned about Isaiah's capacity and willingness to go hurt somebody else, correct?
The student at hand, yes.
And you didn't want that to happen, did you?
Correct.
You didn't want him to leave that auditorium until he was calm, did you?
Correct.
If I called you an administrator, would that be a proper title?
No.
Okay.
Attendance
agent.
Yeah.
Well, you're doing the job of.
Work heavily with the administration, but I'm not, wouldn't be considered.
Fair enough. And the safety of the students is the job of all of the faculty at the school, correct?
Correct.
And by keeping Isaiah in that auditorium, you were protecting, at least at that moment, the safety of other students, correct? I may ask for objection.
I'll have to say no, because it was just after one student.
Well, fair enough. At the time, Isaiah, I'll withdraw that question and rephrase. At the time you had Isaiah in the auditorium, you felt you were protecting the safety of at least one other student, correct?
Yes.
Fair enough.
Yes, sir.
And that's your job as faculty.
Yes.
That's all faculty's job, to protect the individual students, correct?
Correct.
Board's permission. Thank you, sir. I have no further questions.
Okay, any redirect?
Yes.
Okay.
Were you taught, a proper way to restrain students physically?
Yes.
I apologize. Restate your question. I missed the first part of your question.
Were you taught, as an educator, dealing with students, a proper way to restrain students physically?
Thank you.
Yes.
And what is that proper way?
I mean, it depends upon the situation. There's different ways to restrain a student, you know, so that they're safe and not injured, or, you know, you're not injuring yourself.
And so when you were walking Isaiah, holding him, with your arms around him, would that be a proper or an improper way to physically restrain a student?
That's a proper way to restrain a student.
And would grabbing a student by the neck be a proper or improper way to restrain a student?
Objection, it goes beyond, I ask no questions about anybody holding somebody by the neck in my direct examination. I'm sorry, in my clause, I ask no questions about that. So any questions about having a hand around the neck is beyond the scope of my clause.
Didn't you ask him if his first statement said that he choked him on the neck? Choke, you said, did your first statement say choked him, and then he said no, and, because I wrote it.
Yes.
So overruled, because I wrote down, witness statement, 1118, no choking, no crying, and no, I can't breathe. That's what, so you.
Okay, I'll stand corrected. Okay.
Overruled.
Thank you. You may answer.
I'm sorry, can you ask me, I'm sorry.
Would grabbing a student by the neck be an improper or a proper way to physically restrain a student?
Improper.
And was Isaiah a threat at the point that you sat him down in the auditorium?
At that time, no, he still wanted to leave out, but he was not anywhere in the vicinity of the kids were all the way on the playground.
And defense asked you a question about escalating the situation. Was it that Isaiah was escalating the situation within the auditorium? Was he doing that physically or verbally?
A lot of it was just verbal. Well, all of it was verbal. And in the auditorium, he was verbally escalating the situation, particularly at Dr. Pilgrim. He made threats and whatnot.
And how did Dr. Pilgrim respond to that?
First told him to stop, and then I would say he got angry after.
Objection, I call, calls for speculation. Can I finish my objection?
Okay, hold on now, y'all know y'all in front of Bryant. Okay, so number one, always direct every comment to me when you're doing objections and whatnot, even when it appears that your sister or brother counsel is cutting you off. Your Honor, can you ask her to let me, finish my statement? Okay. But counsel, let him finish his objection. Okay.
Objection as it relates to, I think it calls for speculation as to the state of mind Dr. Pilgrim.
Just, I think, yes, I think anger is an emotion that people can see, just normal people, doesn't require any kind of expertise or aforementioned knowledge. You can see when someone's angry, you can see how they react, you can tell what they do and what it shows.
The objection is sustained as to the term angry. You can observe a person's demeanor and a person's actions, but you cannot know what a person is feeling, and anger is something that a person feels. So the objection is sustained.
How do you see Mr. or Dr. Pilgrim reacting?
Yelling back at Isaiah. Kind of pointing at him, letting him know that he wasn't worried about his threats.
Was he getting in his face too?
No, I mean, by that time you could see Dr. Pilgrim was sitting on the stage and he was kind of sitting down and talking to him. He was still kind of like elevated voice.
And did Dr. Pilgrim threaten Isaiah at all?
Objection, I think that's beyond, I don't think I went into Dr. Pilgrim making threats, not making threats on my cross, so I believe this is beyond the scope of my cross.
Sustained.
And I think that he talked about Isaiah making threats and such. He came out in a response. So I think it's only if he opens the door to what he was responding to.
That's not your question though.
Was
So your question, one is leading, but that wasn't the objection. But two, you said specifically, was Dr. Pilgrim making threats towards Isaiah? And if you're trying to ask what did Dr. Pilgrim do and what did Dr. Pilgrim do or say in response to Isaiah's threats, that's a more appropriate question.
that's the question I'm looking for, Judge.
Okay, thank you.
What did Dr. Pilgrim do or say in response to Isaiah,
Well, that's leading.
if anything?
Overruled. Okay. Thank you. Yes, that last word, thank you.
Yeah, he denounced them, I'm not worried about it, I know people around here as well, but no direct threat to Isaiah.
Okay. All right, is this witness all set in terms of, not being recalled or anything? Right now?
Yeah.
Okay, sir, you're free to go. Thank you.
As long as defense doesn't plan to recall them, I have no objection.
I like that idea, but you're free to go. All right, any other witness on behalf of the people? And then can, council approach with the people's OIC. And come over here on the side of the train.
I'll go outside now.
Yeah.
Okay.
This is sweet. And then actually, I guess while he's doing it, you could have the OIC bring this in. You can tell OIC he can bring the witness in.
I'll bring it.
Okay.
What's ready of her?
I'll put this on 3:30. It had to be something. This is it. Do you remember why I set aside 3 days for this?
No.
Maybe I was tired that day. Okay, so that works out because I covered the exam, and I have an exam that I have to continue tomorrow, and I was thinking, watch out, they're gonna have to come back, right? All right.
Seriously, Judge Holmes, she's coming up.
She just getting done, that's all.
Yeah.
Is Ms. Stevenson, what is she scared?
Arraignment bench warrant.
And is it, raise your right hand for me, please, ma'am. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? And tell me your name. Sure. Ms. Perkins, I, forgot to give the, instruction previously, but you've been sitting in the hall, correct? And while you were sitting in the hall, you didn't log into the YouTube live stream. Okay, thank you. You can see. What's her hair? Oh, it's empty, so I'm gonna need this rid.
Oh.
I'm gonna need this rid, so tell them. Is this thing still wrong? Okay, tell them to log back in at 12:30. She's gonna have to wait. Tell Ms. Ritter to log in at 12:30. Let me see. Ms. Ritter is on. Ms. Ritter is on Zoom. Yeah, so just have Ms. Ritter log back in at 12:30. I forgot all about that case. Okay. Okay. All right, counsel, you may proceed.
Thank you. Good morning. Would you please state your name for the record?
Latrina Perkins.
And where are you employed?
Pastor. 1 second. Just let Ms. Stevenson know that we forgot about Ms. Harris, who is down in the phone room, and I'm gonna take the case at 12:30.
I told her.
Oh, okay. All right, thank you, counsel.
And were you employed at Pastor Elementary back in September of 2022 also?
Ms. Perkins, tell me your first name again. I'll call you. Latrina, thank you.
Ms. Perkins, do you know someone by the name of Isaiah Ashford?
I do.
And how do you know them?
I know Isaiah. I'm sorry again, Ms. Perkins, and pull that mic down. The mic, yes, it's movable, and the base, yes. Okay, now you can start responding.
I know Isaiah Ashford. He was a student at Pastor Elementary. He attended there. He was a 5th grader at Pastor.
And do you know someone named Ramon Pilgrim?
Yes, I do.
And how do you know them?
Mr. Pilgrim was the assistant principal at Pastor Elementary.
And what was your role at the school?
My role was the cultural facilitator. Mr. Pilgrim and we worked together. I worked in the in-school suspension when the kids' behavior, if they've been excluded, they would come in my room. So him and I will work hand to hand.
And does there come a time if you learn of something happening or that something had happened between Isaiah and Dr. Pilgrim?
Yes.
And how do you come to learn about this?
Yes, Isaiah had to spend a couple of days in school suspension because of a fight that he had. We gave him about 2 or 3 days. And at that time, Isaiah was getting agitated because of his work and he wouldn't cooperate. So I mentioned to him that he has to cooperate or he will have to go to Mr. Pilgrim. And I noticed that when I said Mr. Pilgrim's name, kind of got it a little worried, like.
Objection calls for speculation as to the mental state of Isaiah Ashford.
How did you see Isaiah react when you mentioned the name Dr. Pilgrim?
His reaction was kind of scared and it's like he didn't want to go. Yeah.
What like physical signs was he displaying?
These are leading, Your Honor. Objection is leading.
Overruled, answer that. His expressions was scared. No. He was saying, no, I don't want to go. because he was afraid.
Objection, same objection as relates to the mental state.
As to the I'm afraid, unless that was something, well, no, as to the I'm afraid, the objection is the same, but everything else.
I think it might still fall under 803(3). As that exists.
Did she say that he said I'm afraid? That's what I thought she said. He was saying no, 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 as if. I thought she said as if he was afraid.
Did he say, no, 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 I'm afraid?
Yes.
Okay, oh,
Thank you, Judge. And do you ask Isaiah about this happening?
Yes, I asked him why. I said, did you tell anyone? And he said, yes, he mentioned to his mom. I asked him, did he want to write a statement about what happened? He said, yes. And I proceeded to give him, papers that we have. If the kids want to write a document statement, he proceeded to write a statement.
And is that the first time that you come to learn of something happening?
Yes.
I'm not further, Judge.
okay. Cross-examination.
Very quickly, Ms. Perkins. Good afternoon. Okay, you learned of an alleged altercation between Isaiah Ashford and Dr. Perkins in November of 2022, correct?
Dr. Pilgrim.
Dr. Perkins, Dr. Pilgrim, correct?
Yes.
Okay. And the incident occurred on or about September 22nd, 2022, correct?
No, when I received.
No, I said the incident, the alleged incident between Dr. Pilgrim and Isaiah Ashford occurred, well, let me start that. Do you know when the incident occurred between Isaiah Ashford and Dr. Pilgrim?
No, I don't know.
Fair enough. Okay. But you learned of this alleged altercation in November of 2022, correct?
Correct.
Okay. And you learned of it through the student, Isaiah Ashford, correct?
Student and also Mr. Gresham. Both.
Okay. You didn't learn of this incident from the Detroit Police Department, did you?
No, I did not.
You did not learn of this incident through Isaiah's parents, did you?
No, I did not.
And you learned of it when young Mr. Ashford, Isaiah Ashford, was in school suspension, correct?
That's correct.
He got in trouble again for fighting. Your
Yes.
statement?
Yes.
And you learned during the course of speaking with young Mr. Ashford that he informed his mother of what occurred, correct?
That's correct.
But his mother never came to you and confronted you or addressed this issue with you, did she? Prior to this interview?
No, she didn't.
Nothing further, thank you.
Any redirect?
No, Judge.
All right, thank you, ma'am. You may step down. You're free to go. Any further witness on behalf of the people?
Not again, people, Judge.
The people rest.
People rest.
All right. Anything on behalf of the defense at this
Your
time?
Honor, we will be calling the witness or two, just for one moment. Your Honor, I'm
You
gonna
may. All raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Sir, can you tell me your name?
Kente Rosser.
Spell that for me.
Kente. Last name is Rossser.
Mr. Rosser, you've been in the hallway to be called as a witness in this case.
Yes.
Mr. Rosser, while you were in the hall, did you log into the court's live stream on YouTube?
No.
All right, then you may come to see that. You may proceed.
May it please the court. Good sir, could you give us your name and spell it for the court report?
Yes, Kente Rosser. First name is Kente. Last name is Rosser, Rossdr.
Do you see, are you acquainted with Dr. Ramon Pilgrim?
Yes.
Okay, how so? Could you tell us?
Yes, we used to work together at Inkster High School.
And how are you employed, sir?
I'm a principal in Wayne Westland Community Schools District.
Okay, how long have you been in education?
19, 20 years.
Okay, and how did you know Dr. Pilgrim? Did you work together?
Yes, I was an English teacher at Inkster Public Schools, and he was a science teacher.
Okay. And how long did you work together?
2 years.
Okay. And during those 2 years, did you have the opportunity to become familiar with Dr. Pilgrim's reputation for peacefulness?
Yes.
Okay. What's his reputation?
I know him to be peaceful, nonviolent, calm.
Okay. Is that reputation geared towards students and adults, or just, or one or the other? Tell us.
Both. Yes.
During the years you worked with Dr. Pilgrim, have you had the opportunity to observe him in a situation in which you would be able to determine his trait for peacefulness?
Yes.
Tell us about it.
Just general classroom management situations, crowd control management situations, observing him in the hallways, interacting with students, staff members, etc. Sporting events, interacting with students, staff members, parents, etc.
As a basis, as a predicator based upon your observations, have you developed a personal opinion as Mr. Bowman's character for peacefulness?
You say it, Bowman.
Bowman, I'm sorry. Dr. Pilgrim's character for peacefulness.
I'm sorry, can you repeat the question? I'm sorry.
Based upon your observations, do you have an opinion, personal opinion?
Yes.
On Dr. Pilgrim's character for peacefulness?
Yes.
Yes. Opinion. What is that opinion?
Yes, he's peaceful. He's peaceful, calm, nonviolent, in my opinion.
Nothing further, thank you.
Any cross-examination?
Yes, Judge.
You may.
Mr. Rosser,
Yes.
fair to say you've seen Dr. Pilgrim interact with a lot of students?
Yes.
And did you also work at Pasture Elementary School?
No.
So you weren't present on September 22nd of 2022?
No.
When was the last time that you worked with Dr. Pilgrim?
2010, I believe.
2010?
Yes.
So fair to say, then it would have been about 12 years since you had worked with Dr. Pilgrim.
Yes.
So in those 12 years, Dr. Pilgrim has gone and worked wherever else? Fair to say?
Yes.
Okay. So, you agree that a person can change in about 12 years?
Yes.
And people can sometimes get angry? Can people get angry?
As a general statement, yes.
Generally, yes. So even someone that you would describe as generally peaceful or peaceful in your opinion, they can be angry sometimes too?
I would suppose.
Have you ever seen Dr. Pilgrim get angry?
Not personally, that I can recall.
When you worked with him, you said you were his English teacher and he was science teacher?
Correct.
And you worked together only about 2 years.
Correct.
Were you in Dr. Pilgrim's classroom when he taught
I have been.
in all those 2 years?
I have been within those 2 years.
Okay, so You had seen him interact with students within his classroom also,
Yes,
but you also taught at the same time?
yes,
So it'd be fair to say that you weren't there for every single interaction with students when he taught?
yes, that's fair.
Would it be fair to say that you weren't present for every single interaction he had with students when he was just in the building?
That's fair.
Are you familiar with what happened on September 22nd, 2022 at Pasture Elementary?
Vaguely.
Just generally what happened or didn't happen?
Yes,
You weren't there?
correct.
And if something was on video, would you dispute video evidence?
I guess it would depend on the video.
You're familiar with what Mr. Pilgrim looks like?
Yes,
Would you be able to identify him on the video if I showed it to you?
perhaps.
This is exhibit 1, it's already been admitted. On part C. Do you see Mr. Pilgrim in that video?
I see what appears to be two individuals close to the stage. From this angle, I cannot discern exactly who is Mr. Pilgrim, if I had to guess.
No
I don't
objection.
want you to guess. Yeah, I don't want you to guess. It's already been admitted. We already know that.
Counsel, while you're doing that, excuse my interruption, the two witnesses that testified asked if they could come back in. Neither of those witnesses will be recalled, correct?
I have no plan to call them.
Okay, they can come in. All right.
So if I told you that that was Mr. Pilgrim, would you disagree with me?
He said objection. He said he doesn't know who it is. So other than anything else, anything else
Well, I
calls
can't
for
believe that you
speculation.
withdraw.
That's what I said.
Right.
Oh.
That's what I said. I called myself.
Right, you
I
thought
said,
that.
"Can't leave."
I know. But it does call for speculation. That part would be the same.
That's fair. So you're an educator yourself, correct?
Correct.
So, as an educator, as a principal now, fair to say that you deal with students pretty closely.
Fair.
And are you aware of a proper way to physically restrain students?
Yes,
And is that something that generally as an educator that you're taught by the school?
by the school or by a third party on behalf of the school, yes.
And what is a proper way to physically restrain a student?
I would object to this line of questioning to the extent, objection is relevant. If the testimony is that you were taught by the school or by an individual, to the extent that we're talking about an incident at Pasteur School, and there's been no testimony that my witness, Mr. Rosser, is familiar with how they are taught at Pasteur School, I think it is irrelevant as it relates to what he learned at another school and how it applies to Pasteur. So relevant to my objection.
I'm just saying generally, as an educator, with students, is there a
Well,
proper way to?
I think your
physically
question
restrain?
is overbroad, so. I think your
I can ask a
question,
more specific question.
yeah, try, narrow that down a little bit.
Would grabbing a student by the neck ever be a proper way to restrain them?
Generally, no.
And would grabbing them by the neck and forcing them into a chair ever be a proper way to restrain a student?
once again, I'm gonna continue, how is this relevant as relates to, because the proper way, I'm using the language that's been brought forth by sister council, the proper way, the proper way is
Mr.
defined.
Can I tell you something about
Yes.
me?
Yes.
I don't want to use hate because that's a strong word.
Mhm.
I really don't like speaking objections.
Oh, no problem. I got it. No problem. No speak. Objection, relevance, same objection.
Okay.
No problem.
Objection,
relevance.
Respond.
Judge, he is an educator. He is able to testify as to his experience as an educator about ways that you can restrain students.
I disagree. Well, strike that. I agree. However, I don't think you laid the proper foundation for the questions that you're asking. So the objection is sustained at this particular point.
Have you received education about how to properly restrain students?
Asked and answered.
Well, that's the foundation then.
That's one of the foundational questions. I'll allow it.
In your training and experience that you received, were you taught to ever physically restrain a student by grabbing them by the neck?
Not that I can recall.
And nothing further, Judge.
You need to redirect. Council, you can also stop sharing your screen as well.
Nothing further, thank you.
I actually have a question for you, Mr. Rosser.
Yes.
Rosser. So you answered the question about training. What training does an educator, strike that? As an educator, what training did you receive about restraining students? And so to give context to my question, lawyers go to CLEs, what training did you receive about restraining students?
It's called nonviolent crisis intervention training. NVCI. Yeah.
NVC. Wait a second.
NVCI.
Oh, nonviolent crisis. Okay. And as an educator, at what point in your career did you receive that training?
I don't recall specifically receiving that training prior to 10 years ago. That seems to have become a thing over the last 10 or so years, to my knowledge.
So that would have been like in 2013 or so?
Thereabout, yes.
Okay. When you received the training, were you already an administrator or were you still just a teacher?
I was an administrator.
Okay. And when you worked with Dr. Pilgrim, you both were teachers, not administrators.
Correct.
Thank you. Are there any questions based on my question, Mr. Pitts?
I have no questions, Your Honor.
Any questions based on my questions, Mr.
You said you received the training, you were an administrator. Was it also required for teachers where you were?
It was offered to a few different job titles where I was. Teachers were among those that the training was offered to at the time.
Okay, thank you. You may step down. And you are, I believe, free to remain in the courtroom should you choose, but you're also free to leave. Any other witness on behalf of the defense?
Yes, Your Honor, we're gonna call Dr. Pilgrim.
Okay, stand up, and state your name for me, sir.
Ramon B. Pilgrim,
What does the B stand for?
Vincenti.
Thank you, and Dr. Pilgrim, your lawyer has indicated that he intends to call you to testify on your own behalf. Do you understand, sir, that you have an absolute right to remain silent?
I do.
Do you understand that anything you say can and will be used in my decision with respect to this case?
I do.
Has anyone threatened you in any way or promised you anything to get you to give up your right to remain silent?
No.
Do you understand that while you can consult with your lawyer about whether or not you will testify, that the decision of whether or not you testify is yours and yours alone?
Yes.
Is this your personal decision to give up your right to remain silent and testify in this case?
Yes.
All right, and sir, you may come around. Yes. You can stop right there. Raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you may be seated in the witness box. Mr. Fitch, you may proceed.
May it please the court. Good afternoon, Dr. Pilgrim. Can you spell your name? Give us your name and spell it for the court, please.
Ramon B. Pilgrim. Ramond. Middle name Vincenti, the middle initial is B. Last name is Pilgrim. Capital Pilgrim.
Okay. No, I've addressed you as Dr. Pilgrim. What's your educational background?
I'm a doctor of education. I received my bachelor's degree from Western Michigan University pre-med program, majored in biomedical science, a minor in chemistry. I have a master's of science and administration from Central Michigan University. I have also a master's in education, teaching, secondary education, with concentration in biology. I have a specialist in education, concentration in ed leadership. I just recently earned my doctor of education from Central Michigan in ed leadership. But I'm not teaching during the summertime. I usually work at Wayne State Public Mountain Program, and I do a lot of mentoring. I'm not doing credit recovery for classes relevant.
Let me do this. Let me direct your, thank you very much. Let me direct your attention to 9/22/22. Okay? Were you employed on that day?
Yes.
Okay, can you tell us where you were employed?
Pastor at elementary and middle school.
Okay. What, if any, position did you hold at Pasteur Elementary School?
I was the assistant principal and the dean of climate and culture.
And how long, as of 9/22/22, how long have you been in education?
Approximately 20 years.
Okay. And as the assistant principal at Pasteur, do you have any oversight responsibilities?
Yeah, my job pretty much is to protect the safety of the school and make sure that no harm comes to my staff and students. And then I do disciplinary as well in the school, along with other administrative duties given to me by the principal.
Okay. You oversee any faculty?
Yes.
What's the number of faculty at the at Pasteur back in the date and time in question, September 2022?
I have about 62 faculty, 56. 56. I have 8 men. I'm the only male administrator. I have Mr. Grisham, my typical agent, and then I have maybe 3 males in the classroom. The rest are food service, custodial. The majority of the remaining of the building are ladies.
Okay, can you keep your voice up?
Yes, all and the remainder of the 50 teachers are women.
The mic, you can actually pick it up and move it closer to that way, and then that way it'll pick you up a little bit more. Yeah, that's probably good.
Thank you, Donnie.
Just take your time and so we can hear you.
Okay, that's fine.
All right.
That's fine.
That's better, actually.
All right. Let me address your attention specifically back to 9/22/22. Was there an encounter that occurred between you and Isaiah Ashford?
Yes.
Okay, what happened?
It was lunchtime. Mr. Ashford had got into an altercation with another student. When I saw him, I observed him, it appeared that he was angry, upset. He was yelling and threatening, making threats. He had threatened my staff. He has threatened students and faculty. And then when happened after that was, yeah, I saw him, he appeared like he wanted to go back outside and fight again. He was just irate in the hallway, right where the middle of the main entrance of the building was.
Did there come a time when you entered the auditorium?
Yes.
Okay.
Yes.
When you entered the auditorium, did you see a Mr. Grisham?
Yes.
Did you see Isaiah Ashford?
Yes.
What, if anything, did you observe occurring between Isaiah Ashford and Mr. Grisham when they entered the auditorium?
Mr. Grisham had physically brought Isaiah wrestled him into the auditorium.
You have to speak up.
He wrestled him into the auditorium and then he set him down.
What are you saying? What he
Use
observed?
the word wrestle. Your response?
Well, I'll rephrase.
I'm listening, I was just turning.
No, that's okay. That's okay, Jack.
Okay.
When you say wrestle, have you ever seen two people grappling?
Yes.
Okay. When you see them grappling or wrestling, are their arms, is one's arm around the other?
Yes. He was struggling to get Isaiah into the auditorium. And when we were in the auditorium, Mr. Grisham placed him into the auditorium chair.
And you said he placed him verbally or physically? Could you
He
try?
physically placed him into this auditorium seat.
From what you observed, did it appear that young Mr. Ashford was willingly going into the auditorium?
No, actually, he was not. It was clear that he didn't want to go into the auditorium. So Mr. Grisham physically grabbed him and took him in the auditorium. I followed behind. And as we entered the auditorium together, he placed him into the seat.
Did you personally instruct Mr. Grisham to lay hands or wrap his arms around Mr. Ashford?
No.
So once you, Mr. Grisham, and Mr. Ashford, a student, were in the auditorium, what, if anything, happened next?
Well, I was trying to get him to calm down. He was.
There's two men here. Can you tell who him is?
Oh, I was trying to get Mr. Ashford to calm down. He was irate. He was saying threats of violence towards me, how much he wanted to hurt me. He was using profanity at both myself and Mr. Grisham, but more importantly, all he talked about was he wanted to go out and kill the kid, hurt the kid when he was going to do the kid and the other student that he had got into a fight with.
During the course of your time within the auditorium, did Mr. Ashford remain in his seat the entire time?
No.
Tell us what happened.
He got up and tried to leave the auditorium. So when he got up and tried to leave the auditorium, I was actually kind of afraid, kind of concerned about the other students and stuff. I was, my job was basically to protect the safety of the school and the student. So I was more worried about him wanting to do bodily harm to the other students.
Fair enough. Can we play social short? With the court's permission. You can just play the video. Stop. Thank you. Okay. Oh, here we go. I've got it. That's fine. Thank you. Thank you, sister. Good sir. Do you see an individual standing in the doorway?
Yes.
Okay. Do you know who that person is? Okay. Do you see a person with his arm around Mr. Ashford? And who is that, to the best of your knowledge?
That's Mr. Grisham. That's Mr. Grisham.
Can you play the video, please? Stop. Based upon what you recall of those events of that day, what is Mr. Grisham doing at the moment we've frozen on the video? What's he doing?
Mr. Grisham is getting ready to place Isaiah into the seat of the auditorium chair.
Based upon your observations and memory of that day, did Mr. Ashford appear to willingly be, did he appear that he was willing to sit down on his own?
Absolutely not. That's the reason that Mr. Grisham had grabbed him. He was out there making threats and he was just irate in the middle of the entrance to the building. So we had to remove him from that area and put him somewhere where we can sit down and calm him down. So that's why we're in the auditorium to set him there.
When you say we, who is we?
That's why myself and Mr. Grisham went into the auditorium.
Can you play the video, please? Stop. Is there a way we can go back and touch?
Yeah.
Let's just leave it there for a second. Let's leave it there. What, if anything, did Mr. Ashford do after he was placed in the chair by Mr. Grisham? What, if anything, did Mr. Ashford do?
He threatened to kill the other student. He threatened to, he cursed myself and Mr. Grisham out. He was yelling. And at the end, he threatened to harm me, basically kill me. But I kind of ignored that because I wasn't really worried about that. I was more concentrating on, safety of the kids and stuff.
Were you personally concerned about your physical safety for Mr. Ashford?
No, I'm 6'3", 280. I'm not really concerned about my physical safety. I'm more concerned about the safety of the other kids, especially that kid he got into an altercation with.
Did Mr. Ashford, based upon your memory of these events, remain in the chair after he was placed in the chair?
No, he didn't.
What, if anything, did he do?
He tried to leave the auditorium. There's a door.
Play. Good, thank you. Stop. Okay.
Go back a little more.
So that's fine. Okay. You see what we have on the screen, correct?
That is correct.
Okay, what is, to the best of your knowledge, what, at the moment we frozen on the screen, what is Mr. Ashford doing?
Mr. Ashford.
What did he appear to be doing?
He appeared to be leaving the auditorium. There's another door that's parallel to the entrance that we have on the other side. You can't see it, but it's a door it's parallel, it's to the right. It's a door that leads directly out towards the students.
So would it be a fair statement to make that there's another door that is not captured by the camera?
That's correct.
Based upon your knowledge of your memory of the events that day, did it appear to you that Mr. Ashford was headed toward that?
Yes.
Council, I'm gonna interrupt you. It's 12:31. I anticipate that this testimony, even including the cross, is gonna at least take us a couple of hours. Do you all agree? No?
I don't know about hours.
I don't.
Maybe an hour?
I don't see it going, we were kind of getting to the heart of the matter. I anticipate wrapping up my direct within 5-10 minutes.
Yeah.
This is my anticipation.
If you want to take like a 30-minute break.
No, I want to take an hour break because it's lunchtime for my staff, but I have to do one case, so I was thinking this was a good place to stop. So, but if you said you're gonna finish up in 10 minutes, then I perhaps should let you finish and then stop. What is your?
I'd like to continue.
Okay, so give me one moment.
Okay.
And then,
Okay, yes.
everybody stay put. Okay. Can you stop your screen share? Yes, get Ms. Harris, please.
Would you request it with being like, I will be there about 10 minutes?
Yes, but you have an exam.
I'm supposed to meet him at 12:30 for another case. Not
Oh.
an exam, just another hearing.
Okay, well, I mean, if you have, so maybe this is a good place to stop.
It's 10 minutes, it's fine.
I would just, course discretion, whatever everyone wants to do, I can continue or.
That's great.
Okay.
Yeah, it's no sense in me to just having wait if this is a good place to break, so I will stop, we will be in recess until 1:30. Remember, you are under oath, of course, you can talk to your lawyer, and that's it, no one else. And then we're in recess until 1:30, so be back here at 1:30. You're welcome.
To the podium right now.
Yes, to the podium. Yes, yes, I'm sorry, sir, yes, you step down and then you are relieved. And then. What case is this? All right. This is case number 204527601, the people versus Shanita Harris. Defendant is charged with malicious destruction of a building, and today is date set for an arraignment on a bench warrant. Appearances, please.
Good afternoon, Your Honor. Christina Ritter on behalf of the people, number 83505.
For the record, Your Honor, Janice Stevenson appearing on behalf of Ms. Shanita Harris. Ms. Harris, ma'am, please tell the judge your full.
Shanita Lynn Harris. All right, today's the day set for an arraignment on a bench warrant, and I believe Ms. Harris' case is at the pretrial conference in 2022. Ms. Stevenson. Maybe in 2021. No,
She's still standing.
No, ma'am. Okay, she gave me, it looks like from her January 13, 2022 pretrial conference. Ms. Stevenson.
Stands mute, waives the reading of the information, asks that a plea of not guilty be entered on her behalf, that the matter be rescheduled for pretrial conference, and that the $50 bond posted for today's hearing be continued.
The court is going to enter a not guilty plea. As to the arraignment on the bench warrant, set the matter for a pretrial conference, February 14th at 8:34. Bond will continue with no contact with the complaining witness. Who is the complaining witness?
Well, Judge, it looks like in this case, the building in question is owned by an apartment complex located at 14792 Greenfield.
What's going on, man? What's going on?
We'll get to it.
Okay. So the building is owned by who?
The apartment complex.
So a representative of the apartment complex should appear.
Absolutely, Judge, and we're just asking for no contact with that address in question.
She doesn't live there. Is this an apartment complex?
It is an apartment complex, Judge.
Ms. Stevenson, to your knowledge, does your client live there?
Can I know the address of the apartment complex?
Oh, well, now that we're gonna say she lived there, so hold on. Let me say that, let's just see. No, the apartment complex is on Greenfield.
That's not her address, Your Honor.
All right, so no contact with the apartment complex. And then if I didn't already say it, the bond will continue. Does she have another court date with Judge Holmes? Because I don't want to have to wait till 12 o'clock again.
She has to go back now when she's done with this.
So they didn't give her a court date? I would ask them to try not to give her to February 14th.
Okay.
Okay. All right, anything further?
No, thank you, Your Honor. Thank you.
Nothing on behalf of Ms. Harris. Thank you, Your Honor.
All right, then we're all set until February the 14th at 8:34. Plainly, this is required to appear.
Thank you, Your Honor.
Thank you. All right, we're recessed until 1:30.